Good morning, everyone. Welcome to today's webinar on how to successfully sell your business, some tips for a successful sale, where our main focus will actually be on kind of negotiating the terms of your sale agreement. My name's Anthony. I'm the co-head of legal here at LegalVision. I'm also a practice leader in the corporate and commercial team and have many years of experience working in the mergers and acquisition space. Before we begin, just a couple of quick housekeeping items. All attendees will receive a recording and slides from today. You can actually submit questions in the Q&A box as part of this, and we'll try to answer all of the questions at the end of the webinar. And at the end of the webinar, we actually have a short survey and would really appreciate your feedback at the end. Also, all attendees are eligible over the next 48 hours to receive from us a free consultation just to discuss on how we could potentially assist you with your legal needs in your business. So just to request that free consultation, just provide us your contact details at the end of the survey that appears at the end of the webinar. Cool. So today we'll be discussing a variety of things. As you can see on this slide, we'll be going into, first of all, just a little bit about which deal structure that you should approach, a brief slide on terms sheets or heads of agreements, getting ready for a sale of your business, and then we'll kind of go into some very specific areas of negotiation within the sale contract, mainly being around purchase price, conditions precedent, and then trying to limit your liability as sellers in the spaces of warranties and indemnities. So on the next slide, the first kind of issue we want to discuss, and it's always the one of the first key decisions you as a seller need to make is whether you're selling your business as an asset sale or a share sale. So an asset sale is where all of the business assets are sold to the buyer, versus a share sale where you are selling to the buyer all of the or most of the shares in the company that you've been operating your business for. Both have advantages and disadvantages. From the perspective of an asset sale, there are a lot more administrative steps that come with that, particularly in having to deal with 2P regulations, assigning over contracts and leases and transferring IP and the like. Generally, as a seller, you need to look at what's the risk profile. So from the buyer's perspective, they will consider an asset sale as being a less risky endeavor, and that's because they get to pick which assets of the business that they want to take on, and generally are leaving the liabilities of that business behind and not assuming those liabilities. Whereas in a share sale, you're buying the company, all of the shares in the company, which means that you kind of are taking on, as they say, all the skeletons in the closet of that particular company. That kind of segues into a difference between the two deal structures around due diligence, which is the investigations that a buyer will usually do for the particular business that you're looking to sell. Generally, there's a little bit less DD in an asset sale versus a little bit more DD done in a share sale transaction. But I think the biggest key point for you as sellers is what's the tax outcome and what's the best tax outcome for you as sellers. Now, generally, that's going to be a share sale. That's going to be generally a more tax efficient way for you to dispose of your business versus an asset sale. But it's just one of those points that, we always recommend having a chat with your accountant, because obviously we want to try and, as sellers, minimize the total amount of tax that we're paying as part of the sale. So on the next slide, another kind of key part of the initial steps of looking to sell your business is that the parties will usually enter into what's known as a heads of agreement, or sometimes it's known as a term sheet, or a letter of intent. So also, this is really a document about the parties coming to coming to an agreement on what are the key commercial terms for the deal. What the price are, what some key conditions will be, what's if there'll be security, things of that nature. Um, and it's really important from the perspective of at least getting people on the same page. Now, term sheets and heads of agreement are largely non-binding documents, other than for very specific types of provisions. So usually it's the case that the buyer might want to impose, let's say, on you an exclusivity period, so that you, the seller, can't go off and talk to any other buyers during a period of time. So as sellers, you'll try your best to, I guess, minimize how long that period is, because obviously, if negotiations kind of fall over, then you need to be able to get back out there in the market, and looking to sell your business. Um, from your perspective as sellers, it's also quite usual for the term sheet to include a binding confidentiality clause. That's going to be really important as well from your perspective if you've not had the other side sign a non-disclosure agreement or a confidentiality agreement. Of course, if you haven't had the other side, sign one of those documents, ideally you should. Why is that important for you as sellers? Well, you're obviously sharing a lot of confidential information about how you operate your business, your clients, your suppliers, potentially to somebody that is, your competitor. So important to kind of protect yourself from that disclosure. On the next slide, again, kind of like just an initial, tip for all sellers is to really prepare yourself for due diligence. Now, the amount of due diligence that happens in a transaction will always depend on how big the transaction is. For the smaller deals, you can expect it to be more relatively straightforward. For larger organizations, in the more towards the end of their life the cycle, in a more mature stage, where we're talking of millions of pounds of sale, there is going to be a lot more due diligence involved from the buyer. The buyer will do, a full investigation into the target company or the target business, so that they understand what they're buying. And for you as sellers, I think if once you get to that decision in your mind that you're ready to sell, it's important to start getting prepared for that sale process. Collating all of your information, your documents, your registers as soon as possible, because due diligence can be quite an involved process. We'd also always recommend to try and not do due diligence in kind of like a haphazard way, but to have some rigor and structure with that. And a lot of that will be guided by your advisors, and the lawyers and accountants that you engage. But we always say to clients, look, ideally, you should be setting up some form of a data room, and having some sort of centralized list of a questionnaire that you're able to answer requests for information from the buyer, just as that there's structure and a centralized point of where all of this information, answers, and documents are being shared between the parties. And I guess the last tip is that, again, because due diligence can be quite an involved process, it's important to be making sure that you are devoting time towards it. It can be quite disruptive to your day-to-day operation of the business, particularly if you're an owner and really, in there and involved in your business. Doing due diligence will take time. So devote the time, have a team, a project team designated to it that's going to help you get through those requests from the other side. So now we get into issues specifically that we're looking to negotiate in the sale agreement. So on the next slide, we've kind of got one of the first key issues of negotiation and contention, which is the purchase price. Now, the main thing where I'm wanting to look at here is how the purchase price is paid and the mechanisms by which they will be paid, not so much the quantum, because the amount that you ultimately negotiate with the other side will come down to valuations of the business and what both parties see as the value of the company or the business. As sellers, your ideal scenario is looking to try and get as much of the purchase price to be paid on completion and upfront. Ideally, you don't want to have to give the other side any deferred purchase price payments. And when we say deferred purchase price payments, is in a part of the purchase price that needs to be paid at some later point in time. Of course, that is quite common. And we'll speak about that in a moment. For business sales or asset sales, often a question is stock included within the purchase price that you've negotiated, or potentially is stock something that will be assessed immediately before completion? There's a valuation process that the parties will agree to, and therefore the stock will be something that is added to the purchase price that's been negotiated. In a share sale transaction, one of the things that you're negotiating as a seller with a buyer is whether the deal is being done on what's known as a cash-free, debt-free basis. So, which basically means you get to keep all of the cash that's in the company, but you're also selling the company without basically without any debts. Or alternatively, it could be a deal where the parties are negotiating some sort of working capital adjustment. And what we mean by that is usually just kind of leaving in the company a certain amount of current assets to be able to continue to operate the business for a reasonable period of time. Yeah, it's kind of one of those things. I mean, for a seller, you're trying to ideally give if you have to give a working capital adjustment, then an amount that is generally representative of what the business needs to operate for at least a shorter amount of time, so that the adjustment isn't so much an eating into your purchase price. As we were just kind of speaking about before, deferred purchase price payments. So sometimes those deferred purchase price payments are simply time-based. For example, the buyer will pay, let's say, 70% of the purchase price on completion, and the remaining 30% after 12 months or after 24 months. Sometimes those deferred payments are then linked to certain conditions or earn-out condition, what's known as earn-out conditions. And that could be, for example, things like that the company or the business needs to have achieved a particular profit level or a particular level of gross sales. And for you as the seller, if those conditions are being negotiated, then it's important that you're questioning, are those conditions achievable? And also within trying to approach where if in the event that those conditions aren't exactly met, potentially including some sort of sliding scale so that it's not an all or nothing approach. If you don't meet that particular profit target, it doesn't mean that you're not getting any of that deferred purchase price. Instead, maybe you're getting a prorated amount of that purchase price, for example. Another kind of decision for you as a seller to make on any deferred purchase price payments is whether you're charging the buyer interest, because ultimately deferred consideration is really a form of a vendor finance. So you could be charging interest, and if you're not approaching it in a way of a loan, then also making sure that your sale agreement includes provisions that deal with the acceleration of that deferred payment if there is some sort of default event. For basically, what we're talking about there is if the other side fails to pay you an installment by its due date, or maybe the other side goes, insolvent, then accelerating the total amount that's due and owing to you, and making that immediately payable to you, much like you would see normally in a loan agreement. That kind of brings you then to another idea of, well, if you're giving a buyer the benefit of deferred purchase price payments, then should those obligations be secured, and should you receive some sort of security for that? And that security might be in the form of if we're talking about a share sale transaction, that could be a specific charge over the shares that are being sold. It could be in the form, if we're talking about an asset sale transaction, it could be in the form of the buyer giving a general and fixed and floating charge over the assets of the buyer company and the assets of the business itself, also known as a debenture. There could be some personal guarantees, potentially, that owners or founders or holding companies are also giving to secure and ensure that deferred purchase price payment is being paid. And then the last issue we quickly wanted to talk about was the fact that sometimes in deals, particularly the ones that are more complex, consideration to you might not just be in the form of cash. You could be potentially receiving partly cash and maybe some shares in the buyer entity. And if you are receiving shares in the buyer entity, then you need to kind of approach that also as your own little acquisition, and be asking your own due diligence questions about the buyer, maybe looking at obviously maybe any shareholders agreements or articles that you're about to become subject to as a shareholder in that buyer company, and really questioning what are the rights that you have for the particular classes of shares that you'll be receiving in that company. Do you have voting rights? Do you have dividend rights, and things of that nature? In the next slide, we kind of deal with also now one of the, again, a fairly contentious point in sales contracts, which are conditions precedent or conditions to completion. So what are they? They're basically these specific events that have to occur and have to be satisfied, otherwise the transaction won't proceed, and both parties simply get to walk away from the transaction. Now, most of the time, conditions precedent are actually for the benefit of the buyer. So it's definitely something that as sellers, we're going to always be acutely aware of what those conditions are, and how they are framed. So, for example, it's often the case that buyers don't have, all the money up or all the money required to purchase your business. So they will ask for a condition precedent to be that completion is subject to finance. So as a seller, you potentially want to be making sure that you're not avoiding a scenario that the buyer it can only agree or will only receive one specific type of finance, like finance from a bank, that it's not so limiting. It could be any form of finance. If, ideally as sellers, I think you generally want to avoid the buyer having any condition precedent about due diligence. Whilst I know there are some circumstances where parties will just straight away get into signing an agreement and then the buyer does due diligence after signing the agreement. My position is always that it's better for the other side to be doing due diligence well before any sales contract is entered into. And another example is there might be a condition precedent around the existing lease of the business. Maybe the buyer wants to enter into a new lease or wants the existing lease to be assigned over and varied. And if that's the case, again, we want to generally try to avoid language within the condition precedent section of the document that allows that is too favorable to the buyer. So not giving them the right to be able to negotiate those variations or a new lease on terms that are only acceptable to them. Or that they have to at least act reasonably in negotiating those documents. Another important part of the conditions precedent is that because it is largely for the benefit of the buyer, also important to make sure that then the relevant clause within the sales contract includes something in there around both parties doing everything reasonably necessary to try and achieve those conditions precedent. On the next slide, then we kind of get into the two quite well. In the next few slides, we get quite into the heavier parts of the negotiations of a sales contract, which is all about warranties and indemnities and how you limit your liability around those particular issues. Now, in a sales contract, it is completely standard that a purchaser will always require sellers to give a number of warranties about the business or target company. What is a warranty? It is literally a contractual promise about the state of the business or the company, and it will cover things like the business or the company's compliance with laws like privacy or employment laws. It'll cover things like whether the business has complied with paying everybody in accordance with employment legislation and their employment agreements. It'll cover things like, is there litigation or pending litigation or historical litigation. It'll also cover things like your intellectual property. Does it breach anybody else's IP? Have there been claims of other people breaching your IP? Now, if the warranty is not true, which is ultimately what we were talking about when we're saying that what a breach of a warranty is, that at some future point in time, but actually it's proven that warranty isn't true, then the recourse and remedy for the buyer is to initiate a claim against you as a seller for damages, for the loss that they've suffered as a result of that breach of warranty. So it's really important that we as sellers try to limit and carve out the liability for warranty claims. Now, one of the most important ways that we do that is to disclose against warranties. So the general process is, that sellers will, during the due diligence process, obviously disclose a lot of information about the business and the company, depending on what type of transaction we're talking about. Disclose that into the data room. It's also normal then for there to be what's known as a disclosure letter that the seller and the seller's solicitor will prepare before completion. And it will list a whole lot of things that are then disclosed against all of the warranties contained contained in the particular sale agreement. And by disclosing against those warranties, it means that the buyers can't make a claim against you as a seller for things that you've specifically disclosed. Another way to limit liability is to introduce time caps or time limitations on how long before buyer can bring a claim against you for warranties or for a breach of warranties. So that could be, for example, 2 years or 3 years. For tax warranties, it's usually the case that that's a period of 7 years. Another way of limiting liability is around certain monetary caps on claims. So that the buyer isn't able to at least initiate a claim against you as a seller unless the claim doesn't exceed £5,000, for example, and that amount will always change depending on how big the size of your deal is. More importantly, there will always, you should always be negotiating as sellers an overall aggregate liability cap on breach of warranty claims. And that's usually going to be limited to the purchase price, potentially a multiple of the purchase price, but usually it's just the purchase price. Um, as you go through also then all of the warranties, which depending on the size of your deal can be quite, voluminous and extensive. There might be certain statements that you maybe qualify as being so far as you are aware there is no pending litigation against the company, for example. And by adding that language, you are kind of weakening those warranties a little bit instead of them being absolute statements. And then there's some other stuff that usually your lawyers will kind of assist you as sellers in carving out liability in the document, stuff like trying to exclude out indirect or consequential loss, stuff that would be easily found on public registers. One that you often see is changes in law that might happen post completion, things of that nature. And generally, I think this is just something that I think comes up more within the space of asset sale transactions. Is usually you're a seller company, you're selling your business, the seller company is giving all of these warranties. It's often the case that the buyer entity will then want some sort of personal guarantee from directors or shareholders to try and back up those warranty claims. And generally, you as a seller or owner of the seller entity will do your best to try and reject that position. Then we're going to kind of go into indemnities. Now, an indemnity, which is on the next slide, is a contractual promise from you, the seller, to the buyer, saying that you will cover the buyer's any loss that the buyer suffers as a result of specific events. Now, why is an indemnity advantageous to the buyer? It's basically a contractual promise, to pay and compensate them on a pound for pound basis, versus a scenario where a buyer would need to go off to court and try and prove their loss and prove causation and show that there was, a mitigation of losses. They don't really need to do all of that when it comes to an indemnity. They just get to basically ask, as a contractual debt, you to cover all the loss that they suffer as a result of a specific event. And it's arguably a faster and easier route to compensation than having to go to court. So generally, as sellers, we want to try and avoid giving any indemnity to the buyer for a breach of warranty claim. And that's because the buyer still maintains its rights at common law to come after you and instigate a claim against you for a breach of warranty. If you give them an indemnity, specifically a breach of warranty, then you're just making it so much more easier for them to cover all these types of loss that they might suffer. So you're not prejudicing their position, but it is way better for you to be rejecting that type of indemnity. Typically, what's the indemnities that are acceptable within sale agreements are for very specific issues that the buyer may have come across during the due diligence stage that they are asking of you. So, for example, it could be the case that you have an ongoing claim against a supplier, let's say, that will continue on with the business, and it hasn't been resolved by the time of completion. The buyer might be asking a specific indemnity from you as sellers, to cover any losses or judgments that are made against the company, for example, in connection with that particular claim, which would be reasonable. On the next slide, though, much to the same effect as warranties, you are still trying to put some carve-outs and limitations on the indemnities that you're giving. So ideally, again, you maybe trying to include some sort of time caps. Ideally, you're trying to include some sort of overall monetary cap on the indemnity. So whether that links into the general purchase price indemnity cap that you're offering, or whether you're potentially giving a very specific cap on that indemnity. It just depends on what you're able to negotiate. You usually try and include provisions dealing with how third-party claims might arise from indemnities, and your ability as a seller to be involved, I guess, in those third-party claims, um, or with the idea of trying to mitigate the total amounts that you're going to have to pay. So, you being kept informed of the progress of the claims, you having basically a voice in potentially how those claims are settled. And then, other things and carve outs like limiting direct loss and carving out, that the buyer, any loss that the buyer's contributed, maybe because of their negligence, or their failure to mitigate their loss. So that brings us to the end of the main points we want to discuss here in the webinar. On the next slide, we will kind of be distributing and allow, and you can download by scanning on the QR code, our startup manual for startups, a pretty comprehensive guide of everything you need to know in starting up your business. We're also going to, in a moment, answer some of your questions shortly. But while we do that, I'll take a minute just to describe to you a little bit about LegalVision's membership on the next slide. Sorry, I beg your pardon. Before I go into that, if just to let everybody know that we do actually have another webinar coming up in November, next week, Tuesday, on how to recover unpaid debts from customers and suppliers. So by all means, please join that. Jump online on the link that's been provided, and you can register for that event. But as I was about to say, on LegalVision's membership, becoming a LegalVision member gives you the benefit of getting pretty much unlimited access to a full team of 100 plus specialist lawyers, all for your business as usual legal needs. It's essentially like having your own in-house lawyer for the fraction of or for a fraction of the cost. Our team can assist you with unlimited document drafting, unlimited legal advice, consultations, and unlimited domestic trademark registrations, and much, much more. As a LegalVision member, you really don't need to worry about the cost of lawyers again. Again, thinking about it as of having your own little in-house counsel will take care of all your business as usual legal work, so you can just focus on running your business. And to learn more about our membership, you can request a free consultation when the survey appears at the end of this webinar. I will answer a couple of questions that have come through. One was about trying, what are some of the early processes that you can start in selling to sell your business. I think one way, if you are at that stage of your life cycle that where you are looking to get out, it could be quite helpful to reach out to a business broker. They might be able to, kind of introduce to you, obviously, a raft of potential buyers. I think that's quite helpful. There are also other kind of, again, depending on the size of your business, there are M&A style advisors out there who will kind of work alongside lawyers to help you in preparing for the sale, and might have their also their own network of potential buyers that they could be introducing you to. Another question was around, not exactly around M&A, but about what are the options are there for raising capital. I guess, look, that can be particularly relevant in the M&A space. If you're a buyer, of course, some people like to grow their businesses through what's known as inorganic growth, by just simply acquiring up other businesses. And it's definitely a relevant question in that sense, of where then do you get the capital to make those acquisitions. Sometimes that's by doing a further capital raise, as in issuing shares, additional shares, and finding investors that way. It could be by obtaining third-party finance through a bank, or it could be by issuing other forms of securities, like safes or convertible notes, or securities of that nature. So I don't think we had any other questions for today, so we might just leave it there. Thank you all for your time this morning. If you do have any other questions, please feel free to reach out. And again, there's a 30-second survey at the end of the webinar. We really appreciate for you to provide your valuable feedback. Thank you again so much for joining, and enjoy the rest of your day.